after Minister of Education Nabi Avcı announced that a new regulation prepared on the operation of the dershanes, or university preparation schools, will be published on the official Gazette on Saturday. Educators have accused the ministry of adopting this regulation in a bid to bypass the Constitutional Court's recent ruling to annul a controversial law seeking to close down the dershanes. The Constitutional Court announced a decision on July 13 annulling the controversial law that sought to close down prep schools by a majority vote of 12-5. Soon after the ruling, Ministry of Education officials made statements implying that the operation of prep schools is still not legally possible because of the ministry's regulation in which all the articles related to the establishment of prep schools was eliminated. Speaking to the press in Istanbul on Friday, Avcı said that the new regulation that was prepared about the prep schools has been sent to the official Gazette to be published on Saturday. Giving some details about the content of the regulation, the minister said that the current prep schools might continue to operate as private educational courses if they meet the requirements mentioned in the new regulation. The classroom sizes in those private educational courses that will provide education under 3 groups of science, math, science, and social sciences will not exceed 16. Every student will attend those courses according to their age groups. Those prep courses that have not yet applied to convert to actual high schools will have to apply for those private educational courses before September 1, Avcı said. The minister went on to say that a legal vacuum was caused by the nullification of the law. Since the concept of dershanes was removed from the legislation, the ministry adopted this new regulation to fill this vacuum. Avcı also said that there is no need for students and their parents to be concerned at all, adding that students will be able to have additional educational opportunities to prepare for the university admission examinations. Speaking to today's Zaman, Union of Active Educators, I Time Sen, Chairman Osman Boss said that it does not mean that the ministry is implementing the constitutional ruling by changing the name of the dershanes into private educational courses and bringing the restriction of just 3 lessons for a course. Accusing the government of circumventing the Constitutional Court decision and twisting laws, Boss said that the government continues its anti-dershane steps despite the top court's decision that wants the dershanes to continue to operate just as before. New regulation to lead to more uncertainties. About 3.5 million youths preparing for the university exams were relieved by the Constitutional Court's decision to annul the dershane law, and they thought the uncertainties would end, but the ministry has now triggered another source of uncertainties with its new regulation. The dershanes have not decided whether to convert to these new courses or launch legal proceedings against the ministry for not implementing the top court's decision. If they accept to be converted to those new private educational courses, they will not be able to seek their rights in front of the courts later, because the court will tell them, you cannot claim that the government forces you to convert to those courses since you already accept to be converted. If they do not accept, then they might lose the chance to operate their business, Boss said. Boss also said that the ministry was not able to eliminate the dershanes legally, thus it now tries to stop the operation of those schools via various restrictions introduced with the new regulation, adding also that the new regulation also violates the Constitution, just like the law that the top court found unconstitutional with its annulment. Speaking with today's Zaman, Hanefi Boston, the chairman of the Education Personnel Unions, I Time Sen, Istanbul branch, said that the ministry has to obey the top court's ruling, adding that unfortunately, it becomes a habit for the ministry not to implement the court's decision. Boston pointed to the Ministry of Education's recent decision not to implement the Council of State's June ruling that 8,400 principals who were unlawfully demoted should be allowed to return to their posts. Boston said that the current government does not have any respect for the law and they try to impose their own understanding of the law on the public. Taha Akil, a prominent columnist at the Hurriyet Daily, wrote in his column published on Friday that the Ministry of Education cannot refuse to implement a law annulled by the Constitutional Court by putting the court's decision aside via a new regulation. Saying that the closure of the prep schools was against both the freedom of education and the principle of free enterprise, Akil added that the state can regulate and supervise these institutions, but it cannot close them completely. Avcı also criticized pro-government voices and the Ministry of Education who defend the motion by saying that power to determine the education policy is within the ruling government, saying that such a statement is based on a thinking that sees the parliamentary majority as an absolute power which is also described as the rule of majority. Recalling the Constitutional Court's ruling favoring the prep schools, Avcı said that the protection of rights and freedoms is the founding principle of the rule of law and warned the government that rights and freedoms should be protected despite the majority's will. Supreme Court's decision is precedent for ministry's efforts. The Bugün Daily on Friday revealed that the Supreme Court had previously ruled in favor of a similar case to the cancellation of prep schools law, implicitly warning the Ministry of Education over its efforts to continue hampering prep schools with its regulations. In its precedent decision, the Supreme Court stated, "The Constitutional Court's decision shall immediately be applied. Implementing a law that is cancelled by the Constitutional Court is violating the rule of law." The Supreme Court's decision came after a lawyer's appeal over the Kadki Third Civil Court of First Instance's 2012 decision to dismiss the lawyer's suit on calculating counseling fees by referring to a law. The Court of First Instance stated that it was correct to calculate a fixed price for a lawyer's counseling fee according to Expropriation Law No. 2942. Later on in November 2014, when the Constitutional Court cancelled an article in the expropriation law, the lawyer appealed to the Supreme Court. The Constitutional Court allowed the Parliament to prepare the necessary regulations by deciding that the cancellation should be in effect after July 13, 2015. However, the Supreme Court, in April 12, 2015, ruled in favor of the lawyer and instructed, in a judicial precedent, that the Constitutional Court's decision should be applied at once.